Good afternoon and welcome to those of you that have joined so far. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join before we start. Afternoon, everybody, and welcome to those of you that have joined. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Good afternoon, everybody, and welcome to the Five Stone Buildings webinar programme. I will now hand over to our two speakers today, David Rees and Hugh Cumber.
Good afternoon. My name is David Rees, and I'm joined this afternoon by my colleague Hugh Cumber, and we're going to talk this afternoon about the decision that was handed down by the Supreme Court yesterday in the case of Her Majesty's Revenue and Customs and Parry and others, a case that's often been referred to as the Staveley case. Judgment was handed down yesterday by the Supreme Court, but this is a case that has been going on for a very long time indeed, and relates to decisions that were made by Mrs. Rachel Staveley as long ago as 2006 concerning her pension fund. And it's a case in which I have been involved now for some 11 years, having first been instructed in 2009. As a result of the case's journey through the various courts, something which we will touch upon a little later in this talk, it has become, I think it is fair to say, as a result of the Supreme Court's decision yesterday, a key authority, if not the key authority, in relation to three particular matters. Firstly, Section 10 of the Inheritance Tax Act 1984. And what does that section mean when it refers to an intention to confer a gratuitous benefit? Secondly, it sheds further light on Section 268 of the Inheritance Tax Act and the concept of associated operations, and particularly what do associated operations mean in the context of an intention to confer gratuitous benefit for the purposes of Section 10 of the Act. And finally, the decision also is the first real reported decision on Section 3.3 of the Inheritance Tax Act, and circumstances under which an omission to exercise rights can become taxable for inheritance tax purposes. And that's, and we will go through those sections in a little bit. But to deal first with the facts, the relevant factual matrix for this case starts in 2000. Mrs. Staveley was undergoing a divorce. She and her former husband had built up a company in which Mrs. Staveley had a substantial pension. And as part of the divorce, her pension rights were transferred out of the company scheme into a form of personal pension, what was then called a Section 32 contract. And under the pension rules that existed at that time, Mrs. Staveley's pension was overfunded. And the consequence of that meant that in certain circumstances, one of which was that if she died without taking benefits, the overfunded part of her pension would revert back to the company, and in this particular case, therefore, to her former husband. And unfortunately, the divorce had been an acrimonious one, and Mrs. Staveley was very clear that she was extremely unhappy about the prospect of any part of her pension reverting back to her husband. A point that it needs to be understood at this stage is that the new pension Mrs. Staveley took out in 2000, the Section 32 contract, was a type of pension where if she died without having taken any benefits during her lifetime, the death benefits, the balance of the fund less whatever had to go back to the company, would be paid into her estate and pass under her will to her beneficiaries. And the consequence of that is that the pension and the value of the pension rights, or the value of the death benefit rights, was something that was going to be in Mrs. Staveley's estate because it would pass under her will. In 2005, Mrs. Staveley made a will in favour of her two sons. They were appointed as beneficiaries of the residuary estate. Their interests weren't absolute ones. She set up life interests in their favour with remainder to their children. But the sons were executors, and there were powers within the will enabling them to advance the capital of residue to themselves. So they were certainly intended as the primary persons to benefit under her will. The following year, in 2006, there were various changes to the pension legislation, what became known as A-Day. And as a result of that, it became possible for Mrs. Staveley to transfer the entirety of her Section 32 contract pension fund into a new personal pension plan, what's been referred to in these notes and in the judgments as a PPP. And the consequence of that was that if she transferred into a further consequence of A-Day was that there was never going to be, after that, any risk that any overfunding in her pension would revert back to the company and to her former husband. The entirety of the fund was always going to belong to Mrs. Staveley. Nonetheless, Mrs. Staveley was exercised about this. She was worried that there was the possibility, however remote, that an overfunding could revert back to her former husband. And she sought advice about this, and she was told in October 2006 that she could transfer her pension from the Section 32 contract into a standard personal pension plan, and that there would be no inheritance tax consequences of doing so. Now, that may not have been correct advice, because under the Section 32 contract, as I've already mentioned, the right to the death benefits belonged to Mrs. Staveley's estate. Under the new personal pension plan, the death benefits were to be paid out by the scheme administrator after Mrs. Staveley's death, in accordance with the scheme rules. And the scheme rules permitted payment to people that she had nominated, but it also permitted payment to other people, including dependents, including grandchildren, and indeed her personal representatives as well. And in November 2006, Mrs. Staveley transferred her monies from the Section 32 contract into a personal pension, and she nominated her sons as beneficiaries. Now, by the time she did this, there are two events that had already occurred that need to be borne in mind. Firstly, Mrs. Staveley was dying. She had been diagnosed with cancer in 2004, And although she had initially made a recovery from this, it returned again in 2006, and certainly by November 2006, Mrs. Staveley was dying. Secondly, Mrs. Staveley had earlier in 2006 been advised that it was much better for her sons if she didn't take any benefits from her pension fund during her lifetime, but instead died without having taken any pension benefits, so that the benefit of those death benefits could pass under her will, under the Section 32 contract, to her sons. And she made a decision in June 2006 not to take any pension benefits as a result. As I say, in November, she transferred her money from the Section 32 contract into the personal pension plan, and under that plan, she nominated her sons as beneficiaries. She died a few weeks later in December 2006 without ever having taken any benefit from the personal pension plan. And the following year, at some point in 2007, the administrator of the personal pension plan paid the funds from that plan to her two sons. Next slide, please. The consequence of that was HMRC sought to charge inheritance tax on two events, each of which was said to be a lifetime chargeable transfer for inheritance tax purposes made by Mrs. Staveley. The first of the lifetime transfers was the transfer in November 2006 from the Section 32 contract to the personal pension plan. And HMRC's case in relation to that was that under the Section 32 contract, the death benefits were payable to Mrs. Staveley's estate. Under the personal pension plan, they were payable at the scheme administrator's discretion, so that the value of Mrs. Staveley's estate had been reduced. The second event that was said by HMRC to constitute a lifetime chargeable transfer to inheritance tax was Mrs. Staveley's omission to take pension benefits from the personal pension plan. And the revenue relied on Section 3.3 of the Inheritance Tax Act to say that that was a deemed transfer of value for inheritance tax purposes, and one that took place at the moment before Mrs. Staveley's death. Now, before we deal with the decisions of the various courts, I'll just talk briefly about the three sections that were engaged by this case and how they apply to the facts that I've just described. So in relation to the transfer, two issues arose, the first of which relates to Section 10 of the Inheritance Tax Act. The sons agreed that for the purposes of the Inheritance Tax Act, what Mrs. Staveley had done by transferring her funds from the Section 32 contract into the personal pension plan was a disposition. The issue at every stage in these proceedings was whether or not that disposition was a transfer of value and thus subject to inheritance tax. And the legal arguments related to Section 10 of the Inheritance Tax Act. And that's set out on the slide. And that section provides that a disposition isn't a transfer of value if it can be shown it was not intended and it was not made in a transaction intended to confer any gratuitous benefit on any person, and either that it was made in a transaction at arm's length between persons not connected with each other, or it was such as might be expected to be made in a transaction at arm's length between persons not connected with each other. So the taxpayer's argument was that what Mrs. Staveley had done in transferring her pension from the Section 32 contract into the personal pension plan wasn't itself something that was intended to confer a gratuitous benefit on any person. All she had done is transfer from one type of pension plan under which her sons would be the ultimate beneficiaries of the death benefits to another type of pension plan under which it was also likely that her sons would be the ultimate beneficiaries of any death benefits. But that Mrs. Staveley's intention in making that transfer simply arose because she was concerned to avoid any risk that any part of her pension fund could revert back to her former husband via his company. That was the first issue in relation to Section 10. The second issue was not only that arose out of an argument made by the revenue that, well, even if the transfer itself wasn't intended to confer a gratuitous benefit on someone, it was nonetheless made in a transaction that was intended to confer a gratuitous benefit on somebody. And here, the revenue relied on the extended meaning of transaction that can be found in Section 3.3. And it can be seen there on the slide that transaction includes a series of transactions and any associated operations. Now, associated operations are a defined term in the Inheritance Tax Act. And if we could have the next slide, please. They are explained at Section 268. And they have a very, very wide definition indeed. And as can be seen there, they mean any two or more operations of any kind, being operations which affect the same property, or one of which affects some property and the other or others of which affect property which represents, whether directly or indirectly, that property, or income arising from that property, or any property representing accumulations of any such income, or any two operations of which one is affected with reference to the other, or with a view to enabling the other to be affected or facilitating its being affected, and any further operation having a like relation to any of those two, and so on. And so one can see that, to give that section its literal meaning, associated operations in relation to a trust or a pension fund can mean pretty much anything that is done in relation to that to that trust or to that pension fund. Now, it has always been accepted by the revenue that the section cannot sensibly operate in that way, and that there must be some limits to what constitutes an associated operation. And prior to the decision in the Staveley case, the leading authority on that was a decision of the House of Lords from 1989 called IRC and Macpherson. And that's a case that we will return to later on in this talk and look at in a bit more detail. But essentially, Macpherson identified what might be relevant associated operations for the purposes of Section 10. And here, the revenue's case was that the transfer and the omission by which Mrs. Staveley decided not to take any benefits during her lifetime to ensure that death benefits would be payable for them and that those would go to her sons, were associated operations affecting the same property. And so the revenue's argument was, because they're associated operations, the transfer, when taken with the omission, was made in a transaction that was intended to confer a gratuitous benefit on Mrs. Staveley's sons. The omission itself, and if we can have the next slide, please, is an issue that the charge to tax on the omission itself, the revenue argue, arose under Section 3.3 of the Inheritance Tax Act. And as can be seen there, that section provides that where the value of a person's estate is diminished and the value of another person's estate or of any settled property is increased by the first person's omission to exercise a right, he shall be treated for the purpose of this section as having made a disposition at the time or the latest time when he could have exercised a right, unless it is shown the omission was not deliberate. So here the revenue's argument was that Mrs. Staveley didn't take lifetime benefits from her pension, that as a result of that, the value of her estate was diminished, in that if she'd taken the lifetime benefits, she would have within her estate the lump sum and a guaranteed annuity for a number of years that would be payable into her estate. So by not taking it, her estate had been diminished, and that the sons' estates had been increased by the omission. And the issue here between the revenue and the taxpayers was really, was the increase in the son's estates actually, had that been increased by the emission? Because here, of course, the sons didn't get the property directly. They only got it as a result of the exercise by the scheme administrator of the PPP of the of their discretion under the PPP. And so the issue there in relation to section 3.3 was the exercise of the scheme administrator's discretion a break in the chain of causation such that section 3.3 didn't apply? And I'm going to hand over to Hugh at this point, who is going to explain a little bit about the procedural history of the case.
Hi everyone. It's a bit of a truism in tax cases that at each stage that there's an appeal, the tribunal will reverse the decision below, and that's certainly illustrated by the present case. So I'll run through what happened below as quickly as I can. Although I was only instructed at the Court of Appeal stage, I actually sat in the first tier tribunal hearing as David's pupil, which gives some suggestion of how long this matter's been running. And in that case, as you can see there on the slide, it was a bit of a score draw. On the transfer issue, the first tier tribunal, having heard the evidence, determined that Mrs. Staveley's sole motive in making the transfer from the Section 32 scheme to the PPP was to sever all ties with her husband's company, Morriford. And on that basis, it accepted that Section 10 applied and the transfer was taken outside the charge to tax. Now, in relation to the omission, the first tier tribunal was not persuaded that Mrs. Staveley didn't have any intention to confer a gratuitous benefit. And moreover, it did not accept the taxpayer's argument that there had been a break in the chain of causation between the omission to exercise a right, which in fact predated the transfer. She'd made a similar decision in relation to the earlier Section 32 scheme, and the subsequent increase in the son's estate. Now, faced with that determination, HMRC made the decision to appeal to the upper tribunal. And following that decision to appeal by HMRC, the taxpayers also appealed and were granted permission to appeal in relation to the omission. So both issues went up to the upper tribunal. At that stage, there was a bit of a detour because the first hearing before the upper tribunal took place before Mr. Justice Peter Smith. And having heard carefully the arguments of both sides, Mr. Justice Peter Smith then went on to fail to deliver a judgment. And that had the unfortunate consequence for both sides that they had to go back in front of Mr. Justice Barling this time and argue the case again. Now, that turned out to be fortunate for the taxpayers because they were successful on both issues before the upper tribunal. The upper tribunal rejected the argument of the HMRC that Mrs. Staveley's intention was such as to bring the transfer within the charge to tax. It also accepted David's argument that the intervening discretion of the scheme administrator had been sufficient to break the chain of causation between Mrs. Staveley's omission to take a pension benefit and the subsequent increase in the son's estate after her death. And it's important to think about the chain of events there when one thinks about the omission. Mrs. Staveley was deemed to have made the omission at the last moment that she could have made it, which in her case was sort of the moment before her death. But at that stage, nobody's estate had been increased. Things were sort of held in limbo, and until the scheme administrators decided to exercise their discretion some months later, nobody's estate could be said to have increased. And on that basis, the upper tribunal was persuaded that that intervening discretion by the pension scheme administrator, which was a true discretion and not, as the first tier tribunal had suggested, one that was bound to be exercised in accordance with the nomination that had been made. On the basis of that intervening discretion, they said there had been a break in the chain of causation and that the pension omission rather, fell outside the scope of tax. Perhaps unsurprisingly, HMRC were very unhappy with that outcome and appealed again to the Court of Appeal. They were granted permission to appeal and the hearing took place in 2018. Now, in the Court of Appeal, there was a complete reversal, and HMRC won on both issues. It's worth briefly pausing to see the way that the majority of the Court of Appeal dealt with the transfer issue. Now, they accepted the taxpayer's argument about how Section 10 should be construed as far as the narrow issue of the transfer between the scheme was concerned. The majority of the Court of Appeal, with, I suppose, what one would call a dissent from Lady Arden, as she determined this issue differently, held that it was only because of the associated operations issue, which David set out earlier, that HMRC was successful. They held, in effect, that although on its own the transfer was innocent, it was sufficiently linked with the omission to be tainted by the intention Mrs. Staveley had in relation to the omission, and therefore the transfer was brought back in under the scheme of associated operations. So it might be thought that that was actually quite a narrow win for HMRC in the Court of Appeal in relation to the transfer, because it was only on this issue of associated operations, which hadn't greatly troubled the other courts which had considered the case, that HMRC were successful. And it was from that decision of the Court of Appeal that the taxpayers appealed to the Supreme Court. They were granted permission by the Supreme Court, and the appeal was heard last year. And as we've already heard, that decision was handed down earlier this week. So having set out that very brief scamper through the procedural history of this matter, which is quite storied, I will now pass back to David, who's going to talk about how the Supreme Court determined the issue of the transfer.
Yes, thank you, Hugh. And the way the Supreme Court dealt with the question of the transfer was to break it down into two subsidiary issues. And if one looks at the Supreme Court's judgment, and the leading judgment is given by Lady Black, with whom Lord Reed and Lord Kitchen agree fully. There's a dissent in part from Lord Hodge and Lord Sales. Lady Black refers to what she calls transfer issue 1 and transfer issue 2. Now, transfer issue 1 is this question of what does intended to confer a gratuitous benefit mean when one is looking at the transfer itself. And this is perhaps the most important takeaway from this case, because it is perhaps the path of decision that may have the widest implications for other cases in the future. Section 10, as I described earlier, says that the disposition isn't a transfer of value if it is shown it was not intended or not made in a transaction intended to confer any gratuitous benefit on any person. And within this case, HMRC were arguing for a very narrow approach. What they were essentially saying was that because the sons under the Section 32 contract were going to get the monies as a result of their being beneficiaries under Mrs. Staveley's will, and because the PPP put in place a new set of rights, that is to say the scheme administrator's discretion, under which the sons were beneficiaries, what had occurred was that Mrs. Staveley had created a new set of rights for the sons, and that therefore that showed she was intending to confer a gratuitous benefit. So what one did, the Revenue argued, was look at the legal effect of what comes after the transfer, and if that is different to the legal effect of what was there before, so one has a new set of rights, that shows an intention to confer a gratuitous benefit, even if the overall effect of the new rights are no different, or possibly even are worse and less beneficial than the old rights. So HMRC's case was because one was putting in place these new rights, there was an intention to confer a gratuitous benefit. Now that's an argument that had not succeeded at any stage before. The only judge who had been persuaded by it was Lady Arden in the Court of Appeal. For the taxpayers, Hugh and I were arguing that really this was a question of fact, and what one had to do was look at the position beforehand, look at the position afterwards, and obviously see whether or not the difference in the two positions conferred a gratuitous benefit. But of course, it's not just was a gratuitous benefit conferred. The question the court ultimately had to decide was there an intention to confer a gratuitous benefit? Was there an intention to improve the son's positions? And in her judgment, Lady Black, really adopting what Lord Justice Newey had said in the majority judgment in the Court of Appeal, said she didn't think it was appropriate to speak of a disposition as having been intended to confer any gratuitous benefit if the recipient of the benefit was intended to receive no more than he would have received in any event. And in the course of my argument, one of the examples I used was that if one has a £20 note and that's taken away from you and replaced with a £10 note, it's a bit odd to say that the replacement of going down from £20 to £10 is conferring a benefit on you. Anyhow, the Supreme Court held unanimously on this point that the taxpayer's argument was correct, and expressly they rejected what Lady Black referred to as the revenue's return to zero approach. The revenue's argument at one point almost seemed to be suggesting that you took a point halfway through the transfer where the rights under the old scheme had been expunged and the rights under the new scheme had not arisen. And then one could say, well, the fact that the sons were getting rights under the new scheme was clearly an intention to show a gratuitous benefit, because at this point, mid-transfer, they're entitled to nothing at all. And the Supreme Court rejected that and made clear that what one is looking at is simply the position from position immediately before and the position immediately afterwards. You shouldn't be looking at this position mid-transfer. And this may be of particular practical importance in the future as to how HMRC seek to tax transfers between two pension schemes. So having won on that point, the Supreme Court then still had to consider the associated operations issue and whether or not the transfer here had been made in a transaction intended to confer a gratuitous benefit. And the argument that you and I were running in this case derived from the previous leading decision on associated operations, that of the House of Lords in a case called Macpherson, decided in 1989. And in particular, we had latched on to some wording from the judgment of Lord Jauncey in that case, which was the sole leading judgment of the House, where Lord Jauncey, in trying to determine what was in fact a relevant associated operation, because you'll recall it had been accepted by the revenue that not all potentially associated operations were relevant. Lord Jauncey said, if an associated operation is not intended to confer a gratuitous benefit, it's not relevant for the purpose of the subsection. That is not to say it must necessarily confer a benefit, but it must form part of and contribute to a scheme which does confer a benefit. So, looking at that language, we sought to argue that for operations to be associated for these purposes, it was necessary that each individual step, that each individual operation was itself intended to confer a gratuitous benefit. And so we argued that, well, the omission first tier tribunal found was intended to confer a gratuitous benefit, but the transfer wasn't, and therefore the two of them can't be associated. Now, the Supreme Court rejected that argument. They found 5-0 that it wasn't necessary that each individual step conferred a gratuitous benefit. But nonetheless, they sought to identify or they sought to explain what was required for each step to form part of and contribute to a scheme. And this is the point that we won on. Now, we won here 3-2. Lord Hodge and Lord Sales disagreed with the majority here. And the Supreme Court accepted that even though it wasn't necessary for each individual step to have been intended to confer a gratuitous benefit for them to form relevant associated operations, nonetheless here, the transfer and the omission were not relevantly linked in a scheme. And that is because the relevant scheme here was the scheme that Mrs. Staveley had reached or had created to benefit her sons by not taking a pension. And the majority of the Supreme Court held that the transfer from the Section 32 contract to the PPP wasn't needed to affect that scheme. The scheme itself had effectively been put in place by Mrs. Staveley, making the decision no later than June 2006 not to take a pension. And that the first tier tribunal were entitled to find, or what the Supreme Court admitted was the very unusual evidence in this case, that the decision to make the transfer from the Section 32 contract to the PPP wasn't linked to the omission by motive and was simply and solely done in order to prevent any funds reverting to her former husband and his company. And this meant that the taxpayer's appeal on the transfer issue was allowed, but as I say, by a 3-2 majority. And Hugh's now going to talk about the second part of the Supreme Court's decision.
Now, this was an issue where the taxpayer was not successful. The Supreme Court unanimously dismissed the taxpayer's appeal in relation to the omission. Now David and I were arguing as basically the argument that had succeeded before the upper tribunal, that there had been a relevant break in the chain of causation between the omission that Mrs. Staveley was deemed to have made immediately before her death to draw down on her pension rights and the increase in the son's estate. Now that argument had a couple of sub-points. One suggestion that we put forward was that there was a requirement for the increase in the son's estate and the decrease in Mrs. Staveley's estate to be linked in time. Because of course in this case there had been quite some delay between her omission and the increase in the son's estate. And more generally, we argued that the language that was used in the subsection, which was another person's estate is increased by the omission, required a very close degree of connection, that it was the immediate cause. And if that test had been applied on the facts of this case, the Supreme Court would have been bound to determine it as the upper tribunal had and find that there had been a break in the chain of causation. Now, the Supreme Court wasn't persuaded by that argument. It held that a much looser test of causation applied, and it effectively upheld the reasoning of the Court of Appeal on this point. And they said that all that is required by the statute is that another person's estate is increased by the relevant omission, and that the statute wasn't very concerned with who that other person's estate might be. And so on the facts of this case, although nobody individual's estate could be increased until the scheme administrators exercised their discretion, at the point of Mrs. Staveley's death, it was inevitable that somebody's estate would be increased, even if it wasn't necessarily the son's. It could have been one of the other beneficiaries. And so on that basis, the Supreme Court held that the scheme administrator's discretion was not sufficient to break the chain of causation. Now, one very important point to emphasise here, and in some of the reporting on this case, this has been perhaps misunderstood, is that the situation before 2011, where an omission to exercise a pension right might inadvertently give rise to a charge to tax, was viewed as very unattractive. And as a consequence, Parliament legislated to expressly exclude omissions to exercise pension rights from a charge to IHT, and that took effect from 6th of April 2011. So with this kind of omission, where somebody, perhaps somebody terminally ill, deliberately omitted to exercise pension rights and then died and somebody else's estate was increased by the death benefit, for any death after the 6th of April 2011, that would no longer apply and there would no longer be a charge to tax. However, Section 3.3 isn't just concerned with omissions to exercise pension rights. It's concerned with omissions to exercise any sort of right at all. And one particular kind of right where it might commonly arise is in relation to an option. If you fail to exercise an option which then expires, in many cases, somebody else's estate would be increased. And I think it's right to say that the Supreme Court has applied a much looser test of causation than we were arguing for in this case. And therefore, there's probably a much wider scope for omissions to be caught. All that's required on the Supreme Court's reasoning is that the omission is an operative cause in relation to the increase in someone else's estate. And as we argued, that allows the taxman to look quite a long way back in time to find some event in a long chain of events which is sufficient to give rise to causation, which when there's a later increase in someone else's estate, they can ask for some tax. So this is now the leading authority on Section 3, subsection 3, and this is one of the core charging provisions of the inheritance tax legislation. So this is likely to be very important for taxpayers and those that advise them going forward. That really brings us to the end of what we wanted to say, and maybe a sort of a wider discussion of the importance of this case. As David said earlier, the decision of Section 10 is likely to be the most important aspect of this case going forward. I saw in some of the reporting on this case that HMRC spokesman said that the Supreme Court had upheld HMRC's understanding of the law. Well, on Section 10, that is incorrect. They've been arguing at every stage for the much narrower application of Section 10 that David described earlier. So David, I would think that on this point, this probably changes HMRC's view and it might lead to a change in their guidance, particularly in the pensions context.
Yes, I would agree with that, Hugh. I mean, one of the points that one will find in the revenue manual, revenue inheritance tax manual, is paragraph 17072, when they talk about tax transfers between two pension schemes, they refer to a point, what they call during transit. So halfway between the funds having left the first scheme and arriving in the second scheme. And they say what is in the person's estate at this point is the right to determine the terms of payment of death benefits in the second scheme. This right has value because the member could direct the payment to their own estate. If payment is not directed to the estate, then there may be a loss to the estate, depending on the member's health at the time. And then if they're in ill health at the date of the transfer, the loss may be significant. But I think what the Supreme Court have said about the revenues return to zero approach in the Staveley case may well mean that that guidance has to be reconsidered. Clearly, Section 10 is always case specific because it depends on the intention of the particular transferor. But where there is essentially a commercial transfer from one pension scheme to another, it's going to be harder, I think, for the revenue to look behind that and try and find that inheritance tax is payable, whatever the state of health of the person involved. It may be, that may be less so where one is transferring from a scheme where the death benefits would go into one's estate and then to a scheme where they won't. I can see there that there may well in most cases be an intention to confer a gratuitous benefit. The only reason there wasn't in Mrs. Staveley's case is she had received wrong advice that there was no question of inheritance tax being payable in either event. And unless you get somebody receiving the same wrong but ultimately very helpful advice that Mrs. Staveley received, then this particular case may well be a unique example. In terms of associated operations, it seems to us, or certainly I would think, that what the Supreme Court have done here has provided clarification on the extent to which the relevant intention is required to affect each individual step that is said to be an associated operation. But it's interesting to look at what Lord Hodge and Lord Sales say in their dissent. And they're concerned that the majority have, perhaps by the back door, introduced a new test to decide that, essentially a new test of necessity, and that each step must be necessary, form a necessary part of the scheme. That may lead to problems in the future. Do you agree, Hugh?
I'm not sure I share Lord Hodge and Lord Sales' concern about necessity, because if the relevant question is whether there's a scheme, and I think that must be the law following the majority's judgment in the Staveley case. If the question is whether there's a scheme, surely every step in the scheme must be a necessary, although not necessarily sufficient, part of that scheme. So I'm not sure that creates a tremendous conceptual problem. I think it's right that we've at every stage thought of the associated operations provisions, although they seem very broad on their face, as actually quite narrow in their application. And the main time they're going to be relevant going forward is likely to be deliberate tax avoidance schemes. And Macpherson itself was a species of deliberate tax avoidance. And that was really, on the facts of Macpherson, what led the House of Lords to conclude that there was a relevant associated operation in that case. So, I mean, as you said, these are on very unusual facts. And it's really the very unusual intention that Mrs. Staveley had in relation to the transfer that allowed us to sort of hedge it off and keep it completely separate from the emission. And that's unlikely to be repeated, perhaps.
Yes, and I mean, one of the points that comes out of the majority judgment is how difficult they found this issue of defining the scheme. And that in part, I think, must arise as a result of the fact that this wasn't, as you say, a deliberate tax scheme, but it was a set of events, the culmination of which was that it enabled Mrs. Staveley or Mrs. Staveley's estate to avoid the liability to inheritance tax that the revenue believed would be otherwise payable.
In the context of other tax anti-avoidance provisions, like the like DOTAS, for example, or the general anti-avoidance rule, there's this sort of rule of thumb that you know a scheme when you see it. And I don't think it is obvious when you look at the facts of Staveley that it could be thought of as a scheme, whereas perhaps on Macpherson it does have that kind of smell of being a scheme. So perhaps although conceptually it's hard to define, it may be easier to apply in practice than perhaps Lord Hodge and Lord Sales are willing to give credit for. We have a question, I think, in the Q&A, David.
We had a question, Hugh, last week that we sent in advance, which was asking how this would affect, or would this affect emissions in relation to NHS schemes. And one of the question, and I think one point that's worth just bearing in mind, possibly amplifying, is, as you said, Hugh, a moment ago, the law was changed in 2011 in relation so that emissions to exercise pension rights no longer are treated as transfers of value for inheritance tax purposes, although that change came too late for Mrs. Staveley's case. But it's worth bearing in mind that rule only applies to registered pension schemes. I don't know whether the NHS scheme is a registered one or not, but if one is dealing with an unregistered pension scheme, and there are some unregistered ones out there, then Section 3.3 may still be relevant. I don't know whether any questions on legal issues. I don't want to go into any further details in relation to the facts of the case. They're set out in the judgment. But if anybody has got any further legal questions, we'll be happy to answer those.
Just seeing if any more are coming in on the Q&A, but there don't seem to be. But I'm sure if anyone had any questions arising after the event, those are sort of things we might be able to deal with by email. But in that case, if there aren't any more questions, I think we can bring the talk to a conclusion. Thank you everybody for joining this afternoon. I understand that a recording of this webinar will be made available on our website following the event. But apart from that, thank you all for joining, and good afternoon.
Thank you. Bye.